Welcome to Module 8. We're going to talk about the criminal trial and what goes on in the criminal trial. And we're going to start off with the pretrial proceedings. So the Sixth Amendment, as it says on the screen here and it says in the module, it guarantees you a number of rights. One of them is the right to a speedy trial, another one's a jury, another one is to be confronted with the, be able to confront the witnesses, to be able to have bail, and also be able to know what you're being charged with. You can't get held in jail without being told what you're charged with. So the whole issue here, the whole module, we're going to be talking about the arraignment, the preliminary hearing, pretrial motions, jury selection, opening statements, case in chief, that's the case that the prosecution puts on against somebody, the defense case, they can choose to put on a defense case if they want to, they're not required to, the closing statements that are given to the jury, the instructions given to the jury by the judge, and then on to the deliberations. But for this very first part of the lecture, we're going to talk about just these first three: the arraignment, pretrial, preliminary hearing, and the pretrial motions. So let's talk about how you actually get to court to begin with. One of them is an on-view arrest or a warrant. So the officer sees you driving down the street and arrests you for drunk driving. That's an on-view arrest. Or they do an investigation and they determine that you were a burglar or something, and they get an arrest warrant and they come out and arrest you for that. The other way they can do it is called a grand jury indictment. What a grand jury is, it's a secret proceeding where the panel of people that are sworn in to be the grand jurors, you're selected from the community to be a grand juror, and they're a panel that normally serves for a limited term, maybe a year long, depending on the county. And sometimes they have ad hoc grand juries, so if it's going to be a really big issue, then they'll grab a grand jury. But the grand jury will hear the evidence, and they'll decide whether or not to file charges against you. And during that grand jury hearings, it's secretive in the fact that it's not open to the public, like most jury trials are open to the public. They're closed to the public. The district attorney goes in, they present evidence, the grand jury hears the evidence, and decides whether or not there's enough evidence for criminal charges to be filed. You may remember the Ferguson, Missouri, where the police officer shot the person, and they took it to the grand jury, and the grand jury decided not to indict. The grand jury got to hear the evidence, and from the evidence they heard, they decided that the police officer did nothing illegally, and so they did not charge him with any kind of criminal proceedings. So once you get arrested, your very first appearance in court is the arraignment. And this is a picture of Suge Knight, who was arrested in L.A., depending on when you're viewing this lecture. It was in 2015. He was arrested for murder. The arraignment is the first one that you show up to in court. And what happens is the charges are read to you by the judge. He or she will read off the list of charges, and you're asked to enter a plea. Or you can actually defer to a later hearing to enter a plea, but normally you'd enter a plea. And most people I've seen will plead not guilty to start with. I'll explain a little bit later on in the lecture how some people may plead guilty on their first time showing up. Then the Eighth Amendment says, guess what? You get to have bail. So in most cases, except for capital cases, Suge Knight, I think his bail was $25 million, as it was currently as of March of 2015. And they'll also talk about some restrictions. Some of the restrictions might be if we release you on bail, you're not supposed to contact the witness. You're not supposed to interfere with people. Maybe they might take away your firearms so you won't get in any kind of trouble with firearms. Next slide. The preliminary hearing is the next step. So after you've been arraigned, they'll give you a court date, and the very next time you show up to court, it's going to be the preliminary hearing. Sometimes they call it the PX for the preliminary examination. But preliminary hearing. It only happens in California, at least in in felony cases. So in cases where you're going to go to state prison for longer than a year or face the death penalty, that's a felony case, then you have the right to have a preliminary hearing. Basically, it's a mini trial where they put on enough of the evidence to show that there are enough evidence to charge you with a crime. Normally, there's a very few witnesses there. There might be the main witnesses, and if it's a police officer investigated case, it's a police officer's designated as the investigating officer, and he or she will testify in court. I've done that several times at preliminary hearings where I've gone and I've said, Your Honor, this is the evidence that I found. It's done not in front of the jury. It's only done in front of the court, the judge. And the judge makes a decision whether there's enough evidence to push this thing on to full trial. And the preliminary examination of the PX is not used in a grand jury indictment. If there's a grand jury indictment, it goes straight to trial proceedings. You don't go through the grand jury through the PX process. Some other preliminary motions. One is a 1538-5 motion to suppress evidence. This is a very common one. If you think about it, if you get rid of the evidence you have against the person, then the case may go away. I made a lot of DUI arrests in my career, and I would often get motions to suppress the alcohol test, maybe breath or blood test, or motions to suppress my observations of the person's driving to try to eliminate probable cause. And if they can eliminate some of the evidence, then there might be a chance that the case will be dismissed. So that's a really, really common motion if you have the money to do that. Another one is discovery. And discovery is where both sides tell each other, hey, this is the evidence we have, this is the stuff we're bringing to trial. That way they have a full awareness of what they're facing, and they can make decisions on whether they're going to plead guilty or take it to jury trial or whatever. So that discovery is very important. Another motion involving police officers is a Pitchess motion. And what a Pitchess motion is a motion to look at the police officer's personnel file. And the reason they do this is that they can discredit the witness, the main witness. I remember I made a lot of DUI arrests, so if they could discredit me on DUI arrests, we learned that in a previous module. We talked about an officer that was discredited. If you get discredited on your ability to testify, that's something that they can bring up to the jury, such as if you lied during the report or you cut and pasted stuff in reports. So get used to not cutting and pasting now while you're in college, because you get law enforcement can get you in a lot more trouble than in community college. And then a Brady motion. What a Brady motion, actually it's not a Brady motion, the Brady list or the Brady file, as it's sometimes called. Brady was a court case from 1963, which basically said that if the prosecution has any reason to believe that the witness may not be credible or has solid information the witness may not be credible, then they have to tell the defense attorneys. And so officers that have been disciplined for dishonesty, say you lied on an overtime slip, or you got in trouble doing something at work where you got written up for being dishonest, they can bring that up in court. Officer, were you ever disciplined for being dishonest? Yes, Your Honor, I was suspended for 5 days for lying on an overtime slip. So then the jury hears that, and they may say, hey, you know what, is he lying now? It's unknown. So the Brady list is not a good thing to be on. So that's a Pitchess motion. All right, now we're going to move on to the next section, which involves the trial.